What up, what up, what up? It's your favorite shit-talking squirrel, back for another YouTube video. So we got another round of Simpson shutdowns today.
Shut it down!
And, in the middle of that, I believe we have, an update on Miss Hoarder Lady. So, just real quick before we start, I'm gonna be live streaming tonight at 5:30. We'll probably look at some hearings. It should be a lot of fun if you guys like live content. It'll be at 5:30 PM Eastern Standard Time. So, yeah, just hop here on the channel and join me. I'd love to have you. Alright, beyond that, let's just jump on into the content, shall we? Let's get this.
Teenagers report is now in session. All those having business before the court draw near. The Honorable Judge Simpson presiding.
Court does call the case of Affinity Investments versus Willie Cater.
Good morning, Your Honor. Ronald Ruark for the plaintiff, Affinity Investments.
Good morning, Your Honor. Excuse me, give me 1 minute. Had to run out my job. Good morning, Your Honor. Willie Cater here.
All right. And we're here on your motion to stay the writ.
Yes, sir.
Correct?
Yes, sir.
All right, I denied it. What's your basis for stating the writ?
My basis of stating the rent, Your Honor, is I don't have any problems with paying what the rest is owed to my landlord, but I'm also entitled to a rental property that meet the basic structure, health, and safety standards also of living there, you know, and that's not being complied with my landlord at all on several things.
But, sir, that would be a defense that you would raise in the primary case. Your basis for staying the writ would be payment.
Your Honor, I put 1 month rent in escrow, and I have the rest of the payment also that I would rather put in escrow than to give to the landlords because of this reason right here. Now, I just feel like if I'm out here doing everything I can, even I fell behind, okay, cool, but I'm paying you now and I'm paying my money. I'm also entitled to make sure that the home that I stay in is
that needs to be raised, sir. I'm not going to litigate the case again.
Okay.
And you have to just separate that out. Counsel, how much is owing?
Your Honor, there's still on the original judgment of possession, there's $2,730 that is still owed, and a total
which I have.
Mr. Cater. Go ahead, counsel.
And a total altogether for April, May, June, and July, he still owes over $11,130. $2,730 on the judgment.
No, I don't. I don't owe. Oh my God. I just answered that. No, I don't.
Mr. Cater. You know what? You keep talking. I'm just going to end this hearing and deny your motion.
Shut it down!
Yes, sir.
Am I understood?
Yes, sir.
Counsel, how much is owing on the judgment?
On the judgment, $2,730. Mr. Cater did pay $2,100 on June 16th and $2,050 to the court, which I request be released to my client. So $2,730.
Oh, I understand that, but the $2,050, is that, have you already subtracted that to get to your $2,700 or no?
Yes, I have, Your Honor. He paid $4,150 on the judgment.
After I just want to make sure I'm clear. After the $2,050 is paid, then there's still $2,730?
That is correct, Your Honor.
All right. Is there anything else?
Only that he owes an additional 4 months rent. He keeps getting further and further behind.
No, I don't. Do not owe it.
The last time he said he had paid, the check bounced.
No.
I know, I was here. Mr. Cater, I already warned you once.
Yes, sir, Your Honor.
You keep saying yes, sir, but then you keep talking. There's not a basis for me to stay the writ in this case because the judgment is not even satisfied in terms of the payment into escrow. Even the payment into escrow if paid to the landlord, would not satisfy the judgment in this particular case. And so there just isn't a legal basis. There just isn't a legal basis for me to do so. And so I'm not going to do so. Motion to stay the writ is denied. The writ will issue escrow to the plaintiff.
Thank you very much, Your Honor.
Mr. Simmons, can I say one thing?
I don't know why you would want, you say what you want to say and be very careful what you say to me.
Oh, no, I ain't never been disrespectful to you.
You interrupt. Go ahead.
I would rather pay the amount that's owed to the court. Is that okay?
Not at this point. You need to pay the landlord on the judgment. To stay the writ, you need to pay the amount on the judgment. It's simple.
And the only reason I state that, okay, they will have their payment Monday, Your Honor. Thank you so very much.
Well, you got to beat the writ there. Thank you.
Thank you, Your Honor.
Can I ask you when the writ will be issued?
Mute him and kick him out of my courtroom.
Get the fuck out!
I'm done with him.
Thank you.
Boot him. Court calls case. Douglas Eichenhauer versus Shirley Totten.
Morning, Your Honor. John Calvin appearing on behalf of the plaintiff.
Ms. Totten?
Yes, I'm here.
Okay. All right. Where are we on this case, folks?
Your Honor, we appeared last Friday and explained the situation. Ms. Totten has been living with the plaintiff, and you asked me to send a copy of the lease to show that she was not on the lease. So we emailed that over on Monday. And this is just a termination. The parties have been in a long-term relationship, but that relationship has broken down, long since broken down. My client sent me a message yesterday that she's actually forged his name on a check and cashed it, and also used a credit card without authorization. So he's adamant at this point that he just needs her removed. We're not asking for any money or anything else. We're just asking for her to be removed from the unit.
Ms. Totten, what is your position on this now?
Well, to be clear, two things that he stated last week are not true. I even went to the mental health department. I've never been under any mental health issues, unlike him, but that's another story. Our daughter is not on board with this. She's afraid to say anything to her dad. As far as the check, he gave it to me, and I put it in our joint checking account, and every penny is there.
Ma'am. Okay, let me stop for a moment. How old is the daughter?
She's 28, but she's not on the lease either. He holds this over our head like a cat and mouse game. I'll tell you my week. Sunday, we went to the park, him and I and the dog, like always. Got an ice cream, got Subway. Monday, he was irritated that his lawyer had to give me a copy of the lease. Tuesday, he had teeth pulled, and I had to drive and take our daughter to work and go and get his prescriptions. Wednesday, he told me if anything happened to me, if I got sick, he would let me be there. Then yesterday, he tells me he'll buy me a tent. It's a flip-flop.
Well, folks, I guess if I wanted to deal with family court, I would, but that's not why I'm here. So, ma'am, in looking at the lease, it looks like you're going to have to vacate the premises. However, I have serious concerns regarding the equity of the situation in terms of when you would have to vacate. So, having said that, ma'am, when can you move?
He knows I have no place to go. I went to senior housing. They say it's a waiting list of 2 years, a minimum of a year. The shelter says unless you have kids, you're on a waiting list there too.
Have you guys been together?
Over 34 years. And then he keeps saying, if you give me 10 days, then he has to that day to change it.
No, we're okay. Hold on a moment. You guys have been living together 34 years?
Yes. And I've known him 44 years.
All right, here's what I'm gonna do. Hang on one moment. No, when do we? Okay. That'd be fine. There are certain equitable issues given the circumstances of this case that the court believes it needs to decide. I'm going to set this matter for a final settlement conference and or final trial on June 28th, July 28th, 2023, 3:30 p.m. And that will be in person. And because I'm going to have to look at some things because it seems to me that the only thing that separates this case from any others may be a marriage certificate. And I guess if somebody's been with somebody 34 years and wants me to use the court's power to kick them out, then they need to look me square in the eyes in person.
I will have
July 28th.
I will have Mr. Eisenhower there, Your Honor.
Thank you.
And of course, I will be with him.
No, it's not your eyes I want to look into, but okay, thanks for coming. All right. Linden Park Apartments.
All right, we got one more, and it is a doozy, so buckle up.
Court calls the case of Mutual Property Management versus Robert Beal.
Good morning, Your Honor. Kevin Callahan for plaintiff, P78273. I have with me the owner of the property, Abreet Kaur.
Good morning, Your Honor. Robert.
Go ahead.
I'm sorry, Your Honor. Good morning, Robert Beal here, Your Honor.
All right. Counsel, did you receive a copy of the answer?
We received a copy of the answer by email at 4:36 last night. It's my understanding from our last court date that Mr. Beal indicated that he was having his lawyer appear. No lawyer has appeared on the case. He was required to tender $10,000 into the court's escrow by the 10th of July. I don't have evidence of that. Not to say that it didn't happen. I don't have evidence of it. And he was required to answer the complaint by the 10th of July. And we just received the answer last night that poses zero legal defenses, Judge.
Mr. Beal, do you have an attorney here?
No, Steve Wallace will be hired as of next week. The reason I did not put the escrow in Monday as you required me to and give the answer, my business partner had a stroke in Oregon. I flew to Oregon and I just got back Thursday night. And my wife has already took the funds out the account. I didn't want her to take that a lot of money up there by herself. So I told her I'll start working on that after I speak with you today. But we have all of the rent money.
That escrow was supposed to be in.
Yes, Your Honor, you're right.
Oh, I know. And all right. And the answer was supposed to be in earlier than it is now. And I don't see where you're indicating that any defenses to the amount they're claiming is owed.
The amount they're claiming is owed, we're off a few $1,000s, but not the majority of the rent. The majority of the rent, or the $4,500, is definitely due. I have been going back and forth with the management company to do some things around the house, and they have yet to do everything. But the key thing was the deck and the security of the deck. They told me we were going to put a deck up. They decided not to. I asked them to let me pay for the deck. They said, well, you pay for it. We're not going to reimburse you for it. I said, well, what about if I sell it to you back at 30% after I leave, after the lease is up? They said, no. I said, well, if I pay for the debt, can I take it with me when I leave? They said no. So I have been trying back and forth to go back and forth with them to try to work out an agreement with the deck. I did speak with the county yesterday, Steve, the inspector, and he said by law, they're not required to put a deck up, but they are required to have a security barrier back there. So Steve said he was going to call, Steve, the inspector for the county, said he was going to call the email the owner to see if they can arrange to put a barrier up. Once that barrier is up, I'm fine. I don't have a problem.
How much is owing on this account?
With court costs, Judge, it's $18,944.23. Court costs are $235.
Here's what I'm going to do in this case is I'm going to, the escrow needs to be paid. Mr. Beal, we've been through this before. You always make promises to me in another case. You always make all these promises. There's some excuse, and you're just going to have to put up or not. I mean, I ordered $10,000 in escrow. You said you were going to pay it. I get here today. You didn't do it. I don't have any proof of what are the other things that you're talking about. Don't need it, quite frankly. You were supposed to put the $10,000 into escrow. So, if the escrow is, so I will grant the judgment. If the escrow is paid, then the judgment will not enter. It needs to be paid today. If the escrow is paid today by close of business, then this matter adjourns out to July 21st, 2023 at what time? At 10 a.m. So the escrow needs to get there. If it's not here today, plaintiff's entitled to their judgment for their full amount. If it's there today, then I'll see you guys next week at 10.
Judge, if I may.
I make my orders. You got to follow.
Judge, if I may respond.
Pardon?
If I may respond to that, Judge.
Sure.
Judge, there's absolutely zero reason for us to adjourn this again. Mr. Beal,
counsel,
if I could.
That is what I'm doing. I don't need a response from you. That is what I'm doing.
Judge, I would like to make a record if I could.
I go for it.
Thank you, Judge. At the second court date, we received a possession judgment for the full amount. Mr. Beal was not present. Mr. Beal decided to come later on, and the court set aside that judgment. At the subsequent hearing, Mr. Beal made promises to this court, made promises to us that he has a lawyer, he has the escrow, he has this, he has that. He didn't do anything he was required to, and there's zero legal defenses here. I don't understand why we are adjourning it again when there's absolutely zero legal defenses. If Mr. Beal has some kind of misunderstanding about...
Are you done? Are you done?
I'm not done, no, Judge. I'm trying to make my argument for the record.
Get done.
Shut it down.
Thank you, Judge.
Get done.
Thank you, Judge. Any dispute about a deck is between the owner and the city and has nothing to do with the legal contract and has nothing to do with Mr. Beal's obligation to tender rent. I have an owner here that has been displaced from her house. She's owed over $18,000 and is not receiving a single dime here. I don't know why you're giving Mr. Beal another opportunity when there's absolutely zero legal defenses.
All right. First of all, part of your record is wrong. And absolutely wrong, because that was explained to you the last time. So don't try to distort the record, counsel. The reason that the judgment was set aside is Mr. Beal was attempting to try to get in. We verified it. In deference to somebody trying to sign into Zoom, I set aside the judgment. I explained that to you. So don't try to distort what happened. Second thing, I told Mr. Beal this is what he needed to do. He has given me some reason why he did not do it. Certainly, I question whether or not all of that occurred. But what I did is I said, look, if you were to put the escrow in, he files the answer, we'd have to deal with that anyway. He's saying there's a reason why he didn't put the escrow in. I'm giving him till today to get the escrow in. If the escrow's not in, you get your judgment. It's as simple as that. That's why that's happening. I'm done. Case over. We'll see you next week or not.
Shut it down. Nobody eats.
Oh, man. Oh, it's never, no, not funny. What was that guy thinking? Like, what does he stand to gain by arguing with the judge? It was win-win anyways. If he gets paid, he gets the money. If if it gets adjourned, what are you doing? Oh, I'll never understand people that argue with judges to begin with. Like, do you really think in front of everybody they're just gonna be like, oh, you bring up a good point. I guess I was wrong. The person who's running the courtroom was wrong. I'm just gonna change my ruling after the fact. Like, get the fuck out of here, man! Oh, people are so fucking stupid sometimes. I just want to hit them. That was a lot of fun. I love these Simpson shutdowns, man. They are just, peak. They're I love them so much. They are just, they hit different for me. They take these Zoom hearings to a new level for me. I don't know about you. Let me know in the comments. Do you love them? I do. Alright guys, it's Friday, I'm hype, it's just about the weekend, we got a live stream tonight at 5:30 p.m. Eastern Standard Time. I really hope you'll join me, it's going to be fun, but if not, thank you so much for watching this video. You even watched it all the way through, look at you. You're an awesome, awesome viewer. I hope you're subscribed because you're fucking cool. But if not, consider it. That's all I'm asking, just consider it. It seemed like you like this content. If you stayed this long, I have to assume you like the content. So just, you know, lull it around for a little while. Just live with it for a day and come back if you want to subscribe, because I would love to have you. You are awesome. And with that, I'll see you in the next video. Bye now.